And good morning, everyone. Welcome to the California specific webinar here on February 7th. We just got done with a rather lengthy federal webinar because there was a lot to talk about today in the world of guns. And we have all returned from SHOT. We thank those of you who came by to say hello. It was good to see everyone. And I came back with COVID and survived it, and everybody else seemed to be okay. But except for the Gear Fire guys, our friends at Gear Fire, and some of our Fastbound friends came down with it as well. But you know, that's SHOT Show for you. It was nice to be back on the floor. It was good to see everyone. It was huge this year. I mean, it was huge. As if you don't normally get your steps at SHOT, you really got them this year, having to go in between the buildings. They did very nice setup. Everything was very well done. And SSF, I give them credit for pulling that off this year. They did a very good job. We are going to start things off today with Hank. I'm going to let Hank give his business update so that he can pop off and get back to work. And then our director of compliance, Mike Franzak, will give his little update before we hand it over to the California boys. So what do you got, Hank?
Thanks, Brian. And again, it was great seeing everyone out at SHOT Show. It was nice to be in physical presence with everyone again. And you know, it was, as I said before, it was nice to see what SHOT Show used to be, where it was business-minded people there to do business and not just a bunch of riffraff running around in everybody's way trying to do business. It was a great crowd, and it was just a great experience to be out there and seeing folks again. And for those that I saw out there in the California region, it was great to see you again. But yeah, so since SHOT, I really looked deep into multiple data sets that I have access to from different channels of what is the market temperature doing right now. And I can say this with the great degree of confidence. If it hasn't hit your local market space yet, the surge is over to ending right now on huge demand of sales. So consumers are going to start to be more price sensitive as opposed to just getting whatever they can find. Margins are going to start to contract again. And so my point being with that, just seeing as we came out of SHOT Show, some of you may have been at buy group shows here over the last couple of weeks, be really focused on, you know, getting your inventory back to the right levels. If you've got some free cash, don't necessarily buy deep, stick to the onesie, twosie, smaller unit purchases that are the right amount of volume for your store. And instead take that cash and add some diversity to your inventory, whether it's in this industry or take it as an opportunity to go into some other industries, bring some, whether it's fishing tackle, archery stuff, bowling balls, I don't care what it is, but my point being is, we saw the pains of if you're siloed just in this industry and suddenly product supply goes away, how hard and how painful that can be for your business day to day. So diversity is another thing I like to talk about, but the big one is the return of price sensitivity to customers. You may not be feeling it quite yet in your local market space, but I can tell you every data indicator is showing that product leaving the manufacturers, getting into the distribution warehouses, is moving into the distribution faster than it's leaving distribution right now, and getting into the consumer hands. So that's saying that you're going to see distributors building inventory. You're going to see product availability start to pick back up again. And I suffered from it in my store, and I see a lot of folks suffer from it, that when you get that first opportunity coming out of a surge to buy 10 of something instead of maybe getting 1 or 2 of something, and you want to jump on it, I would really caution you to temper that enthusiasm and use that instead as a market indicator to say why this distributor suddenly has a bunch of stuff for me instead of just 1 or 2. That probably means the bloom is off the rose, and stick to your onesie, twosie orders and not go overboard and get stuck with a bunch of inventory that's going to take you a year to sell. That's not what I want for anyone out there. So point being, be really focused on 2 things right now: making sure your inventory is priced right because consumers are getting price sensitive, and making sure that your inventory levels are appropriate so that you're not going to end up with all your cash tied up in inventory for the next year. Those are my 2 big points. If you want to get more specifics, feel free to reach out to me. We can get into some more details beyond that.
Thank you. Thank you very much, Hank.
Thank you. Thank you.
I will see you in a couple days out there in good old Kentucky. We will eat meat and drink bourbon together.
Look forward to it.
All right, buddy. I'll see you in a couple days.
See ya.
Mr. Franzak.
Yes, sir.
I would stick to the inspection details that we were discussing before, because we do know that they're out hot and heavy. DOJ, not so much. ATF is, but then again, there's only like 4 people who work for DOJ, right, guys? So, you know, there's not really much going on out there, but go ahead and let us know what you got for us.
Just wanted to bring up a couple things as I was talking for the last group of people. Is this time of year, everybody's starting to do your taxes. So one thing I wanted to mention about the taxes are your special tax form that is due July 1. Keep in mind, if you're an importer or manufacturer, that there is a reduced rate on there. And that's if your total gross sale, that's where this is where your tax returns come into play for your store. If your total gross receipts for your most recent tax year is less than 500,000, that incorporates not just NFA, but your whole business. So sales of ammunition, sales of accessories, everything. If it's less than 500,000, you qualify for the reduced rate, which is good. And for you, that means you get to pay the 500 instead of the 1,000. And I think, Brian, you said you qualify for that.
Yes, we do.
So I'm glad you get to save some money.
Well, thank you.
But that's coming up. You have any questions on that when you are before you pay your special tax? Let us know. We're glad to help you with that. Understand that if you have some questions. Second thing I wanted to bring up was, as I mentioned before, there are a lot of revocations that are starting to happen around the country. I talked with a few DIOs who said right now in their queue of their office and their division, they have at least 20 going on right now, which is huge compared to where they should be at like 1 or 2 max. Because, and this comes down to, again, the enforcement of those Biden's 5 deadly sins, as we call them: the transfer of a firearm to a prohibited person, the failure to conduct a required background check, and that includes the recheck after 30 days have expired, the falsifications of records, such as the ATF form 4473, not responding to a trace request, and failing to allow ATF to conduct an inspection on your premise. So those are the 5 deadly sins. But again, these are things that are starting to happen. And with that, I'm going to add one other item in there to this, that effective on February 3rd was the secure gun storage. So again, this is something that comes into play too for revocation now. Remember, that is what this means is you have to have available within your store the availability of a compatible secure gun storage or safety device. So what does that mean? Does that mean you have to have 15, 20 of these? No, as long as you have one available, they don't give numbers. As long as you have one available, that is suffice. But it has to be available for a specific firearm or firearms. It can't just be, you have one that's available for a long gun, but of course that doesn't fit some handguns. So you have to have availability of a secure gun storage device for your firearms in your store. And that includes if you take these to a gun show. Again, that's an extension of your premise. Gun show or event is extension of your premise. They have to be available there too for whatever you are selling. So where does this come into revocation? Well, it clearly states in that ruling that if you fail to comply with the secure gun storage, this could be something that causes your store to have their license revoked. So that'll be a violation, and that could come into play again, as with the Biden's, as I say, the Biden's 5 deadly sins that are what a lot of people are having their licenses revoked for. If that comes into play, please give us a call at FFLGuard so we can help you if some of these issues come up during your inspections for not having that. Those are a couple of things right there. What I also want to touch base with you on is do not have Do not send a 4473 via email, a blank one to somebody to complete, to bring it back into your store. There's some issues going on with that right now. That form clearly states on it that they must, that the customer must complete this in the store or at a gun show or event. Do not send it to them to complete, and then they complete it and then bring it to you. That cannot be done. It has to be done in the store, gun show or event. There's been some issues of this going on nationwide, people doing this, and then also selling a firearm off their business premise because they may not be allowed to do that on their business premise, retail sales. So they're doing it at I'd say a storage location where you have the, for household items, whatever, or they'll do the gun sales there. They'll bring the form to them, background check done, and the form has to be done on the business premise. It clearly states that. So make sure that that's not being done. Otherwise, you can be in deep trouble for that also. But that's the main things I wanted to go over with everybody today. If you have any questions again on those locks, everything like that, let us know.
Mr. Palomino Club, Mr. Michel, ladies and gentlemen, without further ado. Are you muted? Can you hear me? Asked to unmute. There we go.
He's still on mute. Yeah.
And so to answer,
Unmute. There we go.
Yeah.
Just got to be smarter than the computer. So there's the context in which everything, all litigation moves now is the countdown to June when the Supreme Court will rule and hopefully reset the meter on how you challenge a Second Amendment law and how a court evaluates that challenge. And hopefully that will mean that a lot more laws get struck down. In the meantime, San Jose is playing games, and the National Association of Gun Rights sued them prematurely, in my view. They filed it the day after they voted on first reading. In order for an ordinance to pass, they have to have a second reading, which is coming up tomorrow. So CRPA and GOC are getting their lawsuit and maybe lawsuits. We may do a federal and a state lawsuit ready to file against San Jose, because that's obviously something that City of LA is already looking at. Obviously, all the gun banning bureaucrats will want to jump on that bandwagon, particularly considering how much media coverage it got. We continue to litigate the Franklin Armory lawsuits. These are more commercial than constitutional. Over DOJ's refusal to add other to the DROS drop down until the law had been changed to declare some of Franklin Armory's products to be so-called assault weapons. We are fighting, getting ready to drop a couple new lawsuits for gun shows. Orange County and now Ventura County they're talking about a bill in Sacramento to ban them in Ventura County. Obviously, they don't want anybody to be able to go to a gun show and talk about guns and actually learn anything about them, because that would facilitate the gun culture. And God forbid, that's a bunch of toxic masculinity, rednecks selling guns to gangbangers at every gun show. So we can't have that. So we're pushing back on that on both First Amendment and Second Amendment grounds. We won already down in Del Mar, then they passed another law, and now we got to fight it again. So trying to remember if we have any run-of-the-mill stuff. Josh or Matt, am I forgetting anything?
No.
So that's kind of the lawsuits. Obviously, the big Second Amendment Hail Mary pass into the end zone is the Supreme Court case. We are queuing up now. We'll probably have at least a half a dozen, maybe more lawsuits that we can drop shortly after the Supreme Court rules. Other than that, there's stuff going on in Sacramento, which I'll let Matt cover.
Okay. We're good. So, all right. Well, I just wanted to touch base on a few things. So first off, the California Department of Justice has released finally its updated new laws for 2022. Of course, it's already a month into 2022, a little bit more than that, and so they've sent that out around. You guys should have seen that through DES. If you guys have any specific questions on any of that stuff, most of it is stuff that we've already discussed and talked about in various information bulletins and questions that you guys have sent in through FFLGuard. Another issue that we're running into, and this is something that I wanted to touch base on, is licensing, specifically at the local level. So all of you California dealers are aware that in order to get both the California Firearm Dealer's License and the FFL license, you also need, of course, any necessary local licenses. In certain jurisdictions, I am starting to see, particularly this year, this month, for whatever reason, that the local license renewals for some dealers are taking an extraordinary amount of time. Of course, the natural excuse being COVID and all that, of course. And so what's happening for some dealers is in processing the renewals for their California Firearm Dealer's License, which is a calendar year renewal every January, it just so happens that these local dealers are also having to deal with the local license renewal occurring in the same time frame. And as a result of that, we've had some dealers that have lost access to DES because the local jurisdiction is telling them that it's going to take 6 to 8 weeks or so to process their local license renewal. And in California, if you don't get your local license renewed within the 30-day window from when your California Firearm Dealer's License expires, you will lose access to DES. So we have seen that. We are dealing with that. And so I encourage you again that if you are running into local licensing issues, that you let us know, number one, but also we can work to make sure that you get your renewal applications in as soon as possible to avoid this issue. So particularly when you're coming up next year at some point, you probably want to think about start renewing probably in October, given the current state of affairs here in California. We are, of course, still waiting for the regulations on what constitutes a firearm precursor part. That has not yet been released or even hinted at by the California Department of Justice. And of course, we have that deadline coming up here in July 1st of this year. So if you are selling what are potentially considered firearm precursor parts, just know that we're still waiting for an official definition and sort of guide that lays out what those are and what is specifically subject to those new restrictions, which will kick in here on July 1st, which will basically treat those parts just like ammunition in the state of California as far as the sale process is concerned. One final thing, the California Department of Justice, since last time we met, the new registration period that is now open specifically for individuals that attempted to register their firearms that were equipped with bullet buttons classified as assault weapons. That opened on January 13th. I believe April 12th is the closing window for that. So if you have customers that are asking you about that, of course, we don't encourage you to give them direct advice, but you can send them to us or any other attorney specializing in firearms law to help them out with that process. There's also information available on the California Department of Justice's website on that process. Outside of that, that's all I have. Josh?
Mute this. All right, there I'm unmuted. All right, hello everybody. And let's talk a little bit about some laws that are taking effect this year. And I wish I could have done that last month, but COVID had me under the weather. But now we can go over them. These are some laws that that passed last year and took effect on January 1. So the first one we have is an expansion of the California Family Rights Act. As you know, or should know, under the California Family Rights Act, an employee is allowed to take at least 12 weeks of unpaid leave to do various things, including for their own injury and recuperation, as well as to take care of certain family members. In 2020, the scope of the California Family Rights Act was expanded to apply to employers with at least 5 employees, which previously had been, you had to have at least 50 employees before the California Family Rights Act would apply. Now it has been expanded to include in-laws, specifically parents-in-law. So if you want to take leave, or one of your employees wants to take leave to care for their mother-in-law,
they're a masochist, but you have to give them that leave. So just bear that in mind. If you're getting requests for time off, there's now an expanded group of folks, including mothers and fathers-in-law, that are appropriate subjects of a leave requested by an employee. The next one that got passed was SB 657. You guys know you have all those posters up at work that talk about things like workers' comp and how somebody accesses workers' comp and what the wage and hour rules are and what, you know, the pay periods are. You got to post all that stuff. Everybody has to buy those posters, those pre-printed posters. Well, if you have employees who are telecommuting, you need to provide them copies of all those notices electronically. So you need to come up with a PDF and email those to your employees so they have them in order to comply with your work site posting requirements. And I don't know that applies to too many folks here, but just FYI, maybe you have some back office person who's no longer working at the licensed location. They're now doing your books or whatever at their house because of COVID and whatever. Make sure that you are sending them copies of all those required work site postings. AB 1003 was passed, and that now in a state where you can rob a Walgreens blind, they have now made withholding wages above $950 grand theft. Now it has to be intentional. So you know, oftentimes when you get into wage and hour lawsuits, the employer will argue the defense of, well, I didn't know I was supposed to pay them that. In those types of situations, if it's a genuine dispute over what the employer was supposed to pay them, then it's not intentional. But if a district attorney can show that an employer was intentionally withholding wages and they're above $950, you as an employer can be charged with grand theft. In California, grand theft is considered a wobbler, which means it can be charged as either a felony or a misdemeanor. So, you know, bear in mind that while California wants to decriminalize almost everything, this is one of the few things they don't want to decriminalize. SB 807 was passed, and it requires you to now keep certain employee records like personnel files, applications, stuff like that for up to 4 years now. Previously, it was 2 years you had to keep employee records before you could get rid of them. The reason they made this change was, as we've previously discussed, the statute of limitations to file a claim for discrimination under California's Fair Employment and Housing Act was expanded a couple of years ago from 1 year to 3 years. And so now they want employers to keep records for 4 years instead of 2 years so that your employees have the ability to get their personnel files right before they sue you towards the end of that 3rd year of their statute. SB 331 was passed. So in 2018, you folks may remember, and we talked about this a little bit previously, California passed a whole bunch of just fun dystopian laws, including one that didn't allow you as an employer to include a non-disparagement or confidentiality clause in a settlement agreement or severance agreement with an employee that prevented that employee from talking about sexual harassment they experienced. So the practice was, prior to them passing the law in 2018, was that if you had an employee that was claiming that they were sexually harassed by a coworker or by a boss, and you settled a case with them, the first thing you would do is say, look, okay, in addition to paying you this money, you're going to agree to not go around and tell your story to everybody, in part because we don't want you spawning a bunch of copycat lawsuits by other employees trying to claim the same thing. Well, in 2018, the state legislature, in its wisdom, decided that, well, that was silencing women and silencing the victims of sexual harassment. So they passed this law that said you can have non-disparagement and confidentiality provisions in a settlement agreement, but they cannot include the victim or the releasor, the employee talking about the circumstances of sexual harassment they allege to have occurred. Well, so SB 331 took effect this year, and that now expands that prohibition on non-disparagement and confidentiality clauses to include any type of harassment, not just sexual harassment. So it includes harassment based on any protected class, race, gender, sexual orientation, disability. And it also requires that you put a special disclaimer in any disparagement clause, non-disparagement clause, or confidentiality clause that specifically informs the employee that that this clause doesn't include any talking about or speaking about sexual harassment, retaliation, discrimination, all that stuff. So just bear that in mind. You know, I'm not trying to downplay certainly the severity or threat of sexual harassment, but I've been doing this long enough to see lots of times where there are just completely spurious claims that are made by an employee, and the employer says, look, I'm going to pay them $5,000 to go away just so I don't have to pay you, Josh, because I'm tired of looking at your face. And as part of paying that essentially nuisance money to make the lying employee go away, you say, and don't talk to other people about this because we don't want your scam to be played out by 20 other employees in the office. You can't do that anymore. So, you know, you can pay them to go away, but they can call all their friends, you know, at the reception desk and tell their gruesome story and start planning for how all of them are going to hit you up as an employer for money. I'm not jaded or anything, by the way. All right. So a few reminders. We talked about this when I hacked and coughed my way through last month's discussion about the California Consumer Privacy Act. Just a reminder, January 1, 2022 is the start date for when you guys need to start cataloging and coming up with a way to be able to search your consumer data. Now, remember, the CCPA only applies to you if you do more than 25 million in revenue, or you get at least half your income derived from selling consumer information, so selling marketing materials, or you have collected 50,000 individual consumers' information. If you qualify under any one of those, and it's most likely the third one, collecting the 50,000 individuals' consumer information, then you need to talk to your IT people or come up with a way to figure out what information you have, how it's stored, and how it can be easily searched, because beginning January 1, 2023, you can expect, particularly from plaintiffs' attorneys, to start seeing requests from consumers about what information you're keeping on them, as a precursor to potentially suing you for not disclosing that information or not responding to the request. So regardless of whether you qualify for the CCPA for purposes of the consumer provision, if you recall, as I was coughing and hacking last week, if you're an employer, which you all are, you have to have this system for your employees, regardless of your size, regardless of how you derive your money, regardless of how much consumer information you have. And again, as we talked about last time, it's much easier to do that with employees because most of that information is going to be kept in a personnel file. But you need to be doing that now, regardless of your size. The CCPA's employer provisions apply to all employers, not just the big ones we identified for the consumer information. Reminder, June 30th of this year is the deadline for employers with 5 or more employees to have some sort of retirement plan set up for their employees. The easiest one is the CalSavers one, which basically is a state-run Roth IRA type system where it's all post-tax money that's paid directly out of the employee's check. And it's the cheapest because most of the fees on that are earned from on the employee side. Really, the only cost for you as an employer to set up a CalSavers is the cost of compliance and tracking in terms of making sure it collecting the money, setting up the payroll, stuff like that. But there aren't any necessarily like matching costs or anything like that you might see with a 401k plan. You can do 401k plans, you can do SEPs, you can do simples, but you have to do something. And like I said, CalSavers is probably the cheapest if you don't already have something and you're not really that excited about setting up a retirement plan. But again, 5 or more, you have to do it by June 30th. If you had 50 or more, you had to do it by June 30th of last year. So if you haven't done it yet and you got 51 employees, set it up now just to attenuate any liability. I don't know that we're going to see a lot of plaintiffs' cases on this particular issue. I think we're going to see a lot more of them on the CCPA stuff, but nonetheless, that's potentially ripe for plaintiffs' attorneys to come in and sue employers who aren't in compliance. And then finally, the great state of California enacted a series of stepped minimum wage increases about 5 years ago, and we have almost hit the top of it. If you have 26 or more employees in California, you now must be paying $15 per hour minimum wage. If you have less than 26 employees, you must be paying at least $14 per hour. And that both of those numbers are as of January 1st. You know, bear in mind, you may be in a jurisdiction which has an even different and higher minimum wage. For example, Los Angeles's minimum wage as of January 1 is $16.04 per hour. Where do they come up with the 4 cents? They tied theirs to increases in the consumer price index. And then cities like Long Beach and certainly up in the Bay Area, cities have special rates for certain classes of workers that are higher than the minimum wage. At Long Beach, I believe it's like hotel and concessionaire workers have to be paid some amount above $15 an hour. I think it's like $15.39 or something like that. But so just bear in mind, you know, check your local laws, but at a minimum, you should, everybody on payroll should be making at least $15 per hour if they're hourly employees. That's all I have for this month. It's good to see everybody again after laying in bed for last month's presentation. I hope everybody does well and everybody's over COVID now.
Yeah, sounds like Chuck's got a little cough over there. Is he now suffering from an illness? We hope you all feel better. COVID was, you know, one day I was down and then I was just kind of tired. Are you feeling all right over there, Chuck? You sound like you got a little cough.
Luckily, it's not COVID. It's just
Okay.
a sinus, Vegas sinus,
Yeah.
pollen and everything else in the air just destroys you.
Mhm.
So I'm now addicted to Afrin.
Yeah, the air filtration at the Palomino Club is terrible.
Yeah, there's a lot of cigar smoke in there and other
Imagine.
particulates that you don't know.
Well, Avis and I have been fielding the help desk questions all week. Of course, mainly they've focused around the safety and storage. And Todd, no, you do not need to have a full-on rifle safe on site. You know, again, you just have to have something that's large. If you're carrying one case in your store, it's got to be large enough to store any type of firearm that you're selling there. I don't think it's any different in California than normal.
So
Good.
I have big 2-3 gun plastic Plano cases, and then I also have gun trigger locks,
Yep.
locks, and cable locks.
Yes, sir.
Okay, but it doesn't have to be a physical steel Liberty safe sitting in the store.
Nope.
Okay.
Locks are included as long as any type of firearm you sell can be secured by what you have as far as safety and storage devices. And you only have to offer one. You just have to offer it, you know?
Okay.
Like we said, we have a client in Sarasota. He doesn't have safes in his store, but he works with a distributor. So you can purchase a safe from him and it'll be delivered in 48 hours. That's
Gotcha.
having something available.
Okay.
Right.
Make a sign that says we can drop ship it, work with the distributor, and they can help you with that.
Yep. What else, Avis? Anything else that, the text messaging?
Yep, we are now text messaging some information out to you, some links to the weekly email that we sent out and things like make sure you don't miss the call. If you are not receiving those text messages, please let us know. We are still in the baby stages, but we are working on it. We are going to not drive you crazy, we hope, with them. What you got, Todd?
Avis, I'm on the my profile page here,
Uh-huh.
and it has my name and it had my correct email, but I went to contact details and it shows my email address is correct. But then I go to put my phone number and it says there's an error.
Ah,
Okay.
shoot me. That could be my problem.
Yep.
So,
Yeah. So here, hold on, watch. Well, hold on, just 1 second.
sure.
We can definitely update that in the system for you.
Hold on, we go here. me see if I can do this. I'm gonna try to do something really crazy here. Watch this.
All right. Well, we will.
There we
keep
go.
On the
All
line.
right, here we go. So if you take a look here, I'll rotate. There we go. So if you take a look, right, oh, now it's not gonna focus in right here.
Not gonna
But see, it
focus in.
says not accepting phone number right there.
Oh, okay. Will you just email me your, or client relations, just email me your, cell
Proper
phone
phone
number?
number. Yep.
Yep, you got it.
Right number?
Easy, I got your email right here.
Okay, shoot it over.
All right. It was good to see the California boys. I will. Oh, so next month we are doing our meeting on Tuesday, the 8th. Monday, the 7th is Lauren's, my sister-in-law's 1-year checkup from her aneurysm and her stroke. So Chris and Lauren obviously will be at the doctor's all morning on the 7th. So we're going to have it on the 8th, Tuesday, the 8th of March. So we will see you all then. Thank you.
Hi, guys.